Amy, I just want to check and make sure my audio is working. Okay.
It is.
Great. Thank you everyone for joining us today. Welcome to our meeting. Appreciate you joining us today. We have a new member, Amy Fender-Sosa, who's going to be joining the group. She's not here yet. Amy Zupko, can you just explain Amy's role with the group and how she'll be assisting us in our project?
Happy to. So Amy Fender-Sosa is one of the Judiciary Council. And so she is in the Legislative Policy and Research Office in the legislature. And she is here to learn more about the project. And once the bill, the concept and the work group decides on language and puts it forward in 2025, she will be the person who is probably kind of the responsible for the bill as it goes to the legislature. For those of you who were here at the very first meeting back in 2020, you might remember Channa Newell was the LPRO Judiciary Council who joined the meeting. Channa has moved on to a new position, and Amy is going to be our person in the legislature on the staff side. So she is great. I think she's been there about 6 years. And if you haven't had a chance to meet her yet, I hope that you all do.
Thank you. Our second agenda item today is just a note about planning for our final decisions on the draft bill in future meetings. For those of you who were here at our last meeting, we reviewed what our schedule will be. We are very lucky to have the resources from Legislative Council of Jessica Menifee and Victor Ruther, and they will be helping us draft for scheduling purposes. They're available basically now and not really available after September. We are hoping to have our bill before the full legislative session in 2025, but that means really time is of the essence. That's good. We've reviewed all of working draft 3. And so we've gone through that. We've identified what open issues are. There are some decisions that we need to make, including the ones we'll be talking about today, that Jessica and Victor need so that they can start their drafting process. But we want to give them as much information as possible so they can start drafting now, be done this summer. If we need to make modifications, we can do that in late summer, early fall. And then have our bill ready to move. So that's why we are having this meeting today, and we'll probably pick up the pace of meetings because of the timing for the drafting. Are there any questions about that, or Krista or Jessica, Victor, or Amy have anything to add about timing in future meetings? So thank you all. So we will be resolving we'll be resolving our open questions. Amy and Krista and I are meeting and working with Jessica and Jim, who've been deeply involved in the project and reviewing our minutes and our meetings to identify what things we want to circle back on, what things we need to circle back on with this group. And that is what we're be doing in the coming meetings and what we are doing today with our discussion of the notice of appeal filing process, which is our next agenda item. So we are returning with this question of the notice of appeal. So just process wise, like I said, we reviewed the draft, we've received the feedback. Based on that feedback, we tried to describe 2 options for the filing of the notice of appeal. Those are described in the memo that was sent to you last week. And also there was an accompanying visual. Neither of these options are the current process, so there'll be efficiencies that would result from whatever option we go with. But what we'd like to do is to review these with you, get some feedback about these possibilities. I think it's helpful at this point for us to think about our overall goals with this project. Those include improving the clarity and usability of these statutes. We want to reduce confusion and traps for the unwary for practitioners and their counsel. We want to improve the efficiency of the process. We want to reduce costs and delays when we can, if there's inefficiencies. And we may also want to make our procedures consistent. We want to make them consistent across the state, so that if people are coming from a justice or municipal court to a circuit court in one county, there's not a different process from how that would work in another county. Obviously, that's helpful for practitioners so that the processes don't vary from county to county, but it seems to just make sense to have consistent processes so that the circuit courts across the state are getting the information in the form that they need, and appellants know how to provide that information. So we'd like it to be consistent across the state. And there may be some benefits to having consistent processes between these types of appeals and other types of appeals. So appeals from your circuit court to your court of appeals, or from your justice or municipal court of record to the court of appeals. Again, that can help eliminate confusion and traps for the unwary. So those are things that we've discussed as our overall goals. I think everyone is here because we want to make these statutes as usable and helpful and clear for all of the people who use them. So I hope we'll keep those goals in mind as we're talking about our options. The other thing that I would suggest is that when we're thinking about the process, it's helpful to think about the process, particularly from the perspective of whoever is the actor at the particular stage we're talking about. So for example, we're going to be talking about the notice of appeal. The actor with respect to the notice of appeal is the appellant, who is going to be responsible for filing and serving that notice. That's one actor. And then the circuit court is the other actor. They're the ones who have to actually use the information provided and go from there. There's other situations where it's the justice or municipal court that's going to be the actor. And so we will want to focus on what's best for that actor, who's the person or entity taking this step, that one of whatever step we're talking about in the process. So I hope you've had a chance to review the 2 processes that we've put in the memo. And as I'm sure you could tell, these are general steps. At this point, it's helpful for us to talk about things at a conceptual level rather than to try and wordsmith through different statutory language. We can identify the concepts, then Victor and Jessica can take our concepts and put them in the statutory language and cross-check that language with all the existing statutes. So that's why the processes are just kind of the steps that someone would follow when filing a notice of appeal. The first step is important, and it will help with the issue of the service of the notice of appeal. So this is the final step in the process for the Justice and Municipal Court. The same in both of the options we've provided in the memo. And the idea here is that it would be helpful if the Justice and Municipal Court at some point and in some ways, whatever makes sense for the Justice and Municipal Courts, because they're the actors at this stage, to get the information about what's the contact information that an appellant will be using in the service? You may already do this. I know in some, circuit court, people provide their contact information. Perhaps it's part of their pleadings or something like that. But you will know if there's some way that you can get information from your parties about their contact for the purpose of service. We haven't tried to say exactly how that will happen because I think you have ideas about how you're already getting that information. But that would be a step, if it's possible, to get, have the Justice and Municipal Courts get the contact information. That's gonna make it a whole lot easier for people to know who to serve. And just to be really clear, the person who has to do the service is the appellant. I know in our discussions, we've heard like, oh, well, we have to try and figure out which prosecuting entity is the entity here, and then we have to have the appellant find out that entity or whatever. We're hoping that maybe there's a process that here the Justice and Municipal Courts can say, this is the way we have this information, or can gather it and put it on a document that will, maybe the judgment or order that just will give the appellant everything they need for service. So that's, even though that's not, that's before the whole notice of appeal, that is a process that I think would help everything after that go more smoothly. So we want to put step one out there. And like I said, it's the same between the two options as something for you to think about, like how would we, that's a potential solution. How could we build that potential solution? We're not going to dive into that, and we're going to plant that seed, and maybe we'll circle back with representatives of your courts and get your ideas on what you're already doing there that might work, or what we could suggest as a way to get that information. So that's step one. And the next step is the completion of the actual document, the notice of appeal, and the service. Again, so they're the appellant is the actor. They're the ones who have to figure out how to complete the notice of appeal and figure out how to do the service. So they're the actor. And so there we would probably focus on what's going to work best for that actor. And then the next step is the filing of it. And this is really what we want to talk about, because there's questions about which court the notice should be filed in. And so the actors there are the appellant who is submitting the notice, and then and then ultimately it's the circuit court that has to act on the information in the notice and open up a case. So, and this is the point where the two options in the memo differ. In the first option, the notice is filed in your Justice or Municipal Court. And in the second option, it is filed in the Circuit Court. Now, that choice between that, the location of the filing affects a number of things. It affects how many people are involved, with basically how many hands are touching the case as it's moving ultimately to the circuit court. So, for example, if the notice is filed in the Justice and Municipal Courts, then the Justice and Municipal Courts have to handle the filing itself, the notice of appeal, and any funds or waivers that are submitted with that, and then transfer those to the circuit court. So there can be more steps and more people involved. The location of the filing also affects how long things might take, because there's just an additional step with the Justice and Municipal Courts before the circuit courts. And it can affect what types of tasks are involved if we have a money transfer. So if there's payment, if you have to pay a filing fee that goes to the Justice and Municipal Court, there can be, as the memo says, questions about, well, can the appellant pay that in cash? If they pay it in cash, how is that transferred to the circuit court? Those sorts of questions are out there. I think one of the legal matters that we've identified with the location of the filing is it can affect, if nothing else, the clarity of when jurisdiction transfers from the justice court to the justice or municipal court to the circuit court. Does it transfer when the file is received? If it doesn't transfer until the file is received, when can the circuit court rule on preliminary motions, like waivers or stays or things like that? And then there's also a difference depending on where the case is filed in the consistency of process between these types of appeals and other types of appeals, because other types of appeals are filed in the appellate court as opposed to the trial court. So that's why this decision matters and how it could affect down later decisions in our drafting. So the first question that I have for the group is simply, is there anything that is fatal that will prevent either of these options from working? Not like whether one's better or not, but like, is there anything that's fatal about either of these options? Like, are they both capable of achieving what in the end needs to be achieved? Transferring the case.
I think so.
We hope so. We hope that the suggestions would work. The options would work. Now, to me, it seems like there are some advantages to option 2, which would be filing in the circuit court. It seems that it could be more direct for the appellant because they're working with the court that will be handling the appeal. The jurisdiction point of transfer would be clear. The circuit court could act immediately on waivers, on stays. I think importantly, there's less work, for the justice and municipal courts. In some appeals, if the notice is filed in the circuit court but never perfected, the justice court doesn't have to be involved at all. There's no cost of time or staff. So that's a potential advantage of option 2. There's no processing of filings or transfer of funds. The appellant goes straight to the circuit court. And then the process could be made more uniform across the state if wherever you are in Oregon, when you want to appeal from your justice or municipal court, you are going straight to your circuit court and working with the processes that are set out in statute and OJD as kind of communicating with all of its courts about how that's done. If we were to do that, the appellant wouldn't be filing in person in the justice or municipal court. They could file in person in the circuit court, or of course by mail in the circuit court. And that's the same for appeals if you were going from a justice or municipal court to the circuit court of appeals or a circuit court to the court of appeals. So that's the same. Some appellants might be closer to their justice court than their circuit court. Some may not. But regardless, everyone could mail into the circuit court. So that it seems like there are some advantages to option 2. You have a single place in a county where everyone is going, and the county court is saying, here's what I need directly to the appellant, and then the appellant is providing that directly to the court. Does option 2, are there values to those differences? Like if we were to have the filing in the circuit court, does that make sense to have it in the circuit court? Yes, Judge Brisbane.
Justice Duncan, if I may.
Yeah.
I would hope that we would broaden our scope a little bit. I hope that the process we settle on for filing notice of appeal will be the same in both justice courts and municipal courts, as you have said. But I think we also need to keep in mind that in justice courts, they have jurisdiction in civil cases, and so whatever, including small claims court cases. So I think we need to keep in mind that whatever the process is, it takes into account that there are some differences in those kinds of cases. In civil cases, you have actions between two private parties, and presumably the service information is known to them. So regardless of whether it's the plaintiff or defendant appealing in a civil case, that party knows the adverse party's service information. And presumably in misdemeanor cases, defendants are represented by counsel in most cases, except for the occasional defendant who chooses to proceed without counsel. And I think we can rely on the presence of counsel to know how to file a notice of appeal, regardless of which rules that we settle on. So I think, but we need to keep, and the other factor that I think of is, when does the local court render its decision? In violation cases, my understanding is typically the decision is rendered and the judge signs the judgment of the court when the person appears in court. So the person, as they walk out of the courtroom, they know what the decision is, and if they want to appeal from it, and if the court has forms available, they can fill out the paperwork right then and there. I think the process in civil cases, including small claims court cases, is probably different, at least in many cases, that a decision is not rendered right on the spot, but rather that either a trial is held and the judge takes the matter under advisement, and probably by letter at some later date advises the parties of what the court's decision is. At that point, of course, the parties are not in the courtroom and do not have immediate access to notice of appeal forms that the local court may furnish. Having said all that, and the chief factor for me when I originally advocated for filing notice of appeal in circuit court is the possibility that there would be motions for stays that would need to be ruled on quickly. But admittedly, my exposure is limited to probably about 20 cases that I looked at in the Marion County Circuit Court, and at least in violation cases, I never saw a motion for stay. And there are so few misdemeanor cases that I don't know that it's an issue there. Even in most civil cases and small claims court cases, you're talking about exchanges of money. And so probably there isn't an urgent need for a stay. The only kind of case that I could think of where there might be an urgent need for a ruling on a stay would be the FED cases that justice courts have jurisdiction of. But I don't know whether that happens often or not. Assuming that it doesn't, I end up concluding that it's better to stick with the current system of having the notice of appeal filed in the local court. I toyed with suggestion, and I think it's possible that we could add to the statutory scheme that if the appellant needs immediate action from the circuit court, the appellant could serve a notice of appeal directly on the circuit court, so the circuit court would gain immediate jurisdiction and knowledge of the case in order to be able to rule on the motion for stay. But I envision that that would not be used very often, and by doing that, we could leave in place the current system of having the notice of appeal filed in the local court, which, at least in violation cases, would allow the local court, as I understand many of them do now, to handle the handle service right then and there. They have a box or some sort of mechanism that they can place a service copy of the notice for delivery to whomever will be representing the city, county, or state.
Judge Brisbane's hand was up.
Hey, good morning. That was a lot of ground to cover. I've been making notes. First, if the notice of appeal is filed in the circuit court, how would the circuit court know if the filing deadline of 30 days is met? In justice court, if someone comes in on day 40, we wouldn't accept it because they missed the filing deadline. We wouldn't accept the notice of appeal. We'd let them know that they missed the deadline. So if circuit court's taking the filing, then we have to hope that they would contact the local court, figure out who it is. If the person's paperwork isn't correct, then they've got to try to figure out where it was filed. We have many courts in our county. We field hundreds of calls a week from people trying to figure out what court to appear in. And I'm not sure about how circuit court is going to know that, because I don't think they're going to take the notice of appeal without either a waiver, deferral, or the filing fee being paid. If they take the filing fee at the time the notice of appeal is filed, then they would have to do a refund if they find out that the deadline wasn't met. I would assume that they would give a refund. So that's one of the issues of, I prefer keeping the filing with the local court. In any type of criminal case, which includes violations, for violations, we also follow criminal procedures. The defendant's in the trial with the person that is the prosecutor. If the person's pro se, which is the majority of traffic violations, then the police officer is the prosecutor, not the DA. And so the defendant's in court with a person that needs to be served, and the court can give them the contact information. That's not a problem, but they're going to know what's going on. They're going to know the court that they started with. They're going to come back here. They've been here for their arraignment if they haven't filed their not guilty plea by letter. And then they're going to be back for trial. So they're going to be familiar with the location, which is another advantage. In our court, we take either a check, money order, no cash, but we send it in a locked envelope over to circuit court with a courier that comes by every day. And when the notice of appeal is filed and the filing fees paid, then we send the entire file that day with the check over to circuit court, or within a couple days. So it's a pretty quick turnaround. If the person is requesting a waiver or deferral, circuit court's not very far away, and we refer them over to circuit court to get that part figured out. And I understand that that's a concern of this group, but that's how we currently do it. As far as eviction cases, there is already a procedure in place for stays. I don't have that right in front of me, so I don't think we need to worry about that. But I would recommend that we keep the filing with the local court. I think it's, well, first of all, for access to justice. We're here all the time, Monday through Friday, 8 to 5. If somebody walks in off the street, we have clerks at the front desk that can help people right on the spot. So there's not going to be delays. Okay, that's my 2 cents. Thank you.
Do you think service is currently happening at the conclusion of cases? Are the notices of appeal being completed and then given to the officers? One question. And then second question, can we provide that the notice of appeal is turned to the justice court and then the justice court forwards it to the people who need to be served?
I'm
What?
sorry, I didn't hear that last part. I know that Judge Kids has a form and the officers served at that point. In my experience, the person decides later, within a week or two, if they're gonna file a notice of appeal. And then they come back, so it's not done right there on the spot.
I see Jordan's hand up, and then if I could enlist Krista to monitor the chat and then go after Jordan and cover what's in the chat.
Uh, thank Jess. I pretty much echo what Karen was saying. I think the locality of the justice municipal courts makes a lot of sense to have them, and the familiarity that the litigants are going to have with that place makes a lot of sense for that to be the filing place. I also I put this in the chat, but I'm also mildly uncomfortable with proceeding on the assumption that most of the defendants in criminal cases are going to have counsel who can help them through this if we don't have actual numbers to support that. In my experience practicing in a couple of municipal courts and justice courts, it's kind of court by court where defendants are going to have attorneys and where they won't. I know, for instance, Eugene, I think the Eugene Municipal Court, I would say most of the defendants are represented. But I've also practiced in several justice courts where they were surprised when the attorney showed up, because attorneys rarely did. So I don't know that we can assume that they're going to have help with that.
Krista on the chat summary, and then we'll go to Jimmy.
Justice Duncan,
Jim, can I go through the chat here real quick? First, the question came up about whether all of the justice or municipal courts are open 5 days a week. There was one response. Does anyone else know if most of the courts are open 5 days a week? It says Tigers closed on Fridays. Some small courts like Gaston are rarely open.
Judge Zemper, you can correct me if I'm wrong, but I believe Eugene is all 5 days, even though we don't necessarily hold regular dockets on Fridays.
Yep, that's right.
And so I guess the follow-up question that Paul had is if a court's not open, how does that affect the filing deadline?
And just to clarify, Justice Duncan, I mean, one of the things you mentioned is sort of uniformity around the state. And I worry that if somebody is appealing from from an order in a justice or municipal court that's only open 2 days a week, say, how do we count those 30 days? Do they have more time to appeal in that situation? Whereas if it's a circuit court, except for situations where there may be weather closures or something in one part of the state or another, pretty much the judicial days are the same statewide.
In my experience, the cities usually delegate to like the finance department or utility billing, which is open 5 days a week, to accept filings and payments. So while the court might not physically be open, there's city services that have the ability where you can make filings. We could also work very closely with the League of Cities to make sure that our cities are accessible. And so the 30-day issue won't be hopefully an issue.
And I would say that might work well for municipal courts. I wonder how that works for justice courts. I'm thinking particularly I know I live in Clackamas County, and county offices are only open 4 days a week. They run on a 410 schedule here.
Okay, I'm in Clackamas County. Justice court's open 5 days a week. We don't follow the county schedule of 410s.
I'm gonna go across the top of my screen, which is Jimmy, Melissa, Judge Kim, Jimmy.
Sure. So I think maybe we need to clarify exactly what role the Justice Court would be playing in this. I had been under the assumption that the Justice Court would really have a purely ministerial task. They get the paper and they send it on to the Circuit Court. But it seems to me that what Justice Courts do in some cases is make substantive decisions about, say, whether the notice of appeal is timely filed, and on that basis decide whether or not to permit the appeal at all. And that seems to be something very different. I'd been under the assumption that the Circuit Court would be the one to decide whether the appeal is timely. Most of the time, that's a very easy question. Sometimes you get a case about whether a notice of appeal in a traffic ticket case was timely filed. That goes all the way up to the Supreme Court. So it seems to me that if this is going to stay with the circuit, with the Justice Court, we should probably be clear that they're not to be making any decision about whether this appeal is permissible. They're just passing it on to the Circuit Court. Or if we're doing something different for that, maybe we need to have a conversation about that question.
I think that is the norm, is that the appellate court decides whether something is appealable, both because it's timely and because it's actually an appealable type order. Those would appropriately be decisions for the appellate court rather than having the trial court decide whether its decision can be appealed. I think that's the norm.
I think that's right, and that had been my understanding, but I think Justice Brisbane's comment suggested that sometimes that they're doing something different from that.
Melissa, then Justin, then Emily.
I'll just start with the comments from Justice Duncan. I agree with everything stated about the benefits of option 2. I think in a lot of ways it would be helpful only because it can take months once a notice of appeal is filed to get everything scheduled. Sometimes we're just constantly checking case management to see if it's even entered in the court system, and it can take months. And when I'm not exaggerating.
Melissa, so where's the delay? And like, is it takes months to get, like the Circuit Court gets it and it's not doing something with it fast enough, or?
I think it can be on both ends. I know that when they're trying to send the register of actions and everything over to Circuit with the notice of appeal, I believe that's the case here. And but then also on the back end, it's once it's received by Circuit Court, I think it's also a delay as well, because it does take quite a bit of time for anything to get scheduled. So I see a lot of the same benefits that Your Honor does, especially with just procedural matters being taken up by the Circuit Court. It just seems to make sense to have a parallel to the Court of Appeals taken in the Court of Appeals, where you're filing your appeal with the court that you're seeking an appeal from. And so I would agree with those. I also wish we could solve all the other issues that Judge Brisbane has raised, as well as Jordan. I'm wondering if that could simply be resolved, one, with like a declaration saying this is within the 30 days, this is the date of the judgment, 30 days have not elapsed. And I think this happens a lot, but if they've done a filing fee and they don't meet the requirements, I believe they forfeit the filing fee. I think that's what usually happens. And I do, from an access to justice standpoint, I agree with regard to situs of the Circuit Court being in a different location than the municipal or justice courts. But I think that also can be easily resolved with just mailing or having an online form that can be submitted as well. These are just, I think, practical issues that I think could be pretty easily resolved. And it's just hard. I see from the perspective when stays are taken and those are ruled on by the municipal court here, it just seems to make more sense that those are ruled on at the Circuit Court. And if it's immediately sent to the Circuit Court, that could be dealt with immediately, as opposed to this back and forth between the two jurisdictions. Those are my comments. Thank you.
Judge Kidd.
Thank you. So I think that filing it at the Circuit Court works pretty okay for criminal and violations matters. I'm worried about filing it at the circuit court, particularly in the context of FEDs. FEDs might be special, might be different, because I always come at this problem from why do we exist, right? We exist in order to increase access to justice and to lift the burden on the circuit court, right? We're a pretty cool tool that way. But I worry that if we, there could be some things that we do with FEDs that make us not a very useful tool. For example, when an FED goes up on appeal, there can be an undertaking hearing, right? And so a lot of times what happens there is the landlord's like, look, this is gonna add like 3 months between the time of now and the time I get another hearing, which is, a $6,000 problem for them of probably rents that are not recoverable. And so I'm worried that if we move the place of appeal to the circuit court, that we lose that undertaking hearing, or we lose any sort of procedural hearing that we might have to help make sure that the landlord might be covered if they have to have a whole different trial 3 months later, right? So sometimes we might ask the plaintiff to pay rent into the court, for example. So I don't know if we did that. I almost wonder if in the FED context, we need to have a special statute that says that the circuit court shall hear the FED in a really expeditious way, right? Or we shall go right to trial. We don't start with the whole like first appearance thing again in FED, right? I don't know. I'm worried about that problem in that context.
I think we have an undertaking section for the civil cases. And so if the undertaking were either available as it is right now in the justice court, that might address the concern.
But I'm worried that it won't happen fast enough, right? It's quite slow, right? And particularly on the civil side, things can be pretty slow moving from our court to the other court, and they start all over at square one, right? So they've gone all the way through trial at my court, and then it goes to Marion County Circuit Court, and they go all the way back to the first appearance. And so that makes the tool not very useful for landlords, right? And so if we do something that takes away some of those safeguards for landlords, people will just stop filing FEDs in our courts, which is, maybe that's what the legislature wants, but it would make us less useful.
Yeah, and I think the undertaking hearing could still occur in the justice court.
Oh, okay. Okay.
Emily and then Judge Brisbane.
Thanks. I can't speak intelligently about FEDs at all, but one of the things that I wanted to flag, I'm fully in support of number 2. As a defense attorney, I always filed them in circuit court, and it always went well, and I could check OECI and see where things were, and that was helpful to me and my clients. And then from an access to justice perspective, when people are appealing my traffic ticket decisions, they don't think that they received justice in my court, and they are abusive to my clerks. And if something goes wrong, and when we say that didn't get there in time, if the circuit court says it didn't get here until day 35, that's going to come back on my clerks or me. And our court, we work 410s in Tiger. There's nobody open in City Hall. Nobody's going to check the drop box on Fridays or anything like that. And it feels, I have real concerns that if deadlines got missed, that it would come back here and we would really have an access to justice issue. The circuit court, they've been so responsive to doing hearings remotely, taking things by mail. They've developed all of these procedures and COVID for dealing with it when folks couldn't get there, that we here at the municipal court level just didn't have the money or time or wherewithal to take care of. So for those reasons, I'm firmly in support of the second route.
Sorry, Judge Brisbane, I see your hand up.
Okay, I agree with Judge Kidd that the process for eviction appeals seems to be different throughout the state. If it worked out to add a statute to make sure that those appeals are handled quickly, that would be a good thing. In Clackamas County, we've worked with circuit court, and in our county, the circuit court takes the case directly to trial if it's an appeal on an eviction, and they have agreed to do it within 2 weeks. So that's just a verbal agreement because we worked it out. And so it's not that way statewide, but that's the way eviction proceedings have been set up in the statutes. We follow the same statutes that circuit court follows, so they're supposed to be done expeditiously, and it would be a good idea if we did have something statewide so that occurred.
I see Tony's hand up and then Lindsay's. Tony?
Thank you, Justice. My thoughts always go back to, I understand what you've all said I see reasons for 1 and 2. I'm an advocate of filing it with the local court. I keep thinking of the folks I've seen at court who don't know that there's a circuit court, or they don't know one court from the other. I think you want to make it simple for the lowest common denominator, if you will, the person that's the least sophisticated to do it. And I don't think there are a lot of appeals filed, but I think it's useful for those folks to not have to think about filing or doing anything in another court that they're not familiar with. They won't do it in many cases. And if you've got people that are represented by counsel, sure, lawyers can handle that. We can figure those things out. But a lot of them aren't. There are a lot of people, even in misdemeanor cases, and most of I don't have any familiarity with civil cases in justice or municipal courts. Mine are, my experience is limited there, and those courts too, criminal, and violations. But I think you want to make it easier for the person that's the least sophisticated, and that's an access to justice issue. I was asked by OCDLA to be on this group. Sean McCrae asked me, and I think that's the kinds of point of view we're coming from. Thanks.
Lindsay?
I had a comment about about a procedural part of these proposals that's the same in both of the options, and that's about the circuit court requesting the case file from the lower court. And my understanding is that the way that it works now is that all of the documents come bundled to the circuit court. So the fee and the record and the notice of appeal. And so that works well because it all comes as a package and it's complete. And so one question I have is kind of that added back and forth of the circuit court requesting the file. And if a notice of appeal is filed in the circuit court, there really might be incomplete information before the court at that time. And then the court will have to coordinate with the local court where it is nice for them all to come together, or at least for the obligation to send the file to be triggered when the notice of appeal is filed in the circuit court. So maybe a service copy would be filed on the local court, and then the local court would send the file after receiving that.
Yeah, I think the thinking is that the notice will come with a judgment, which will give the circuit court what it needs to at least open its case. And if the appeal is not effective because either the waiver is denied or there's no waiver and there's no payment, then the justice court just doesn't ever have to send its file. Looking for other comments. Jim.
Yes. Respecting, one principle I've learned to live by is if it ain't broke, don't fix it. Current law requires that filing of the notice of appeal be in the justice or municipal court. And I have not heard of any problems with that system working. And so if it ain't broke, don't fix it. Requiring filing in the circuit court would require the appellant to get a copy of the notice of the judgment. Maybe that's not a really big deal, but that's one more thing that the justice or municipal court would have to do, which is furnish a separate copy of the front and back of the citation form in violation cases or the judgment in misdemeanor cases. And one other thing I wanted to mention, I don't know that it bears too much here, but I've heard a number of people express the view that service is on the police officer who appeared in the justice or municipal court. That is inconsistent with current law. Current law requires service on the DA in justice court and on the city attorney in municipal court. We may choose to change that, but I think it ought to be clear that service under current law is not on the police officer. It should be either on the DA, either the DA or the city attorney. And that's one of the things I like about filing with the justice or municipal court. Many of them, I understand, already have a system in place. They have a box or something that they simply make a copy of the notice of appeal, pop it in the box to the DA's office or to the city attorney's office, and service is accomplished in that manner.
Krista.
I just wanted to raise what's in the chat, question about even if parties know where the justice court is initially, won't they eventually have to fight the circuit court? So does it matter, I guess, at what point they have to do that?
Well,
I actually have an answer to that. I almost typed out.
I think the current practice is that the justice or municipal court file gets forwarded to the circuit court along with the notice, and the file contains a copy of the judgment, so they have ready access to that information, typically which they need in order to set up the file, to set up the case register.
Jordan, I see your hand. Was that it?
Please, just in response to the comment about them having to find the circuit court eventually, they do, but I still think Tony's right that we need to make this as easy as possible for someone who's trying to perfect an appeal, get it done. And we also should be cognizant that there's a difference between their need to find the circuit court in order to have the appeal hearing and participate in that litigation, and their need to do it to file the appeal. One thing that we should probably be at least have in mind is that for a lot of these people, this is going to mean taking time off work, taking time away from the other things in their day-to-day lives. And if they have to do that to travel to a circuit court, I'm just thinking about Florence, where I used to practice. For someone to drive from Florence to Eugene to file something in the circuit court is an hour drive both ways. If you have a car, it's a several-hour bus ride. And to do that to file paperwork is somewhat prohibitive for them. Now, if they have to take half a day off or a day off to come into a hearing or a multiple day hearing, that's a different thing. But to require them to do something like that to file paperwork seems onerous when they could file it with their justice court or municipal court down the block.
I should say all of these filings can be done by mail too. I see Melissa, and then I thought I saw another Melissa.
Thank you, Your Honor. I wanted to just put in perspective the practicality of this, at least from the criminal perspective. I would venture to say we have, and this is probably being generous, 6 to 10 actual appeals that can be taken to circuit court per year. I think that's probably a higher number than I should say. We have, and this is a recent issue that just came up with one of our defendants, filing appeals that are not okay appeal. So they shouldn't be perfected in circuit court. But they filed the notice of appeal because it was based, and when I say they shouldn't be, it's because they pled guilty on a case and they filed a notice of appeal. So our judges do not rule on whether or not it's an okay appeal to be filed into circuit court. We wait, so we had to wait a month and a half after the guilty plea was taken to file a dismissal in circuit court. So this case had been sitting in circuit court after the notice of appeal for a month and a half before we could actually file the dismissal before a case was generated. So there's just this case sitting there and judgment stayed because, and then we couldn't file anything for a month and a half. So in terms of like brass tacks, what this looks like boots on the ground wise, these are the things that I'm talking about, having just having it go to circuit court first and the circuit court ruling whether or not it is an appeal that may be perfected and have a de novo trial. We could have gotten rid of that really quickly if it was filed directly with circuit court. So I just wanted to like put that in perspective, practical matters for defendants that maybe think that they have a right to appeal, but they don't.
And I see a comment from Jimmy in the chat, and then we're approaching the end of the hour, so we'll wind things up. Jimmy, after that.
This, I can just read the comment. I think there is some risk that, I think this maybe goes back to a comment that's made earlier, which is when the whole appeal is with the circuit court and the filing is with the circuit court, the sort of lines of responsibility are very clear. Like, if there's some dispute about whether the notice of appeal was filed right or not, it's either my fault or the circuit's court's fault. There's not some third thing introduced. And I think along similar lines, the fact that the initial filing needs to be in one court, but then if there has to be, say, further dispute about a fee waiver, you need to go to a totally different court. I think that's not really intuitive. I think I understand the idea of making the initial step as intuitive as possible, but I wonder if that risks creating some confusion that makes the next step you need to take even less clear.
Well, we used our hour on this topic. You did receive with your agenda materials on small claims. We'll take those up at our next meeting. If we've heard different perspectives and good reasons for these two approaches, we can give some thought to whether there's some sort of hybrid approach that might work. If anyone has additional thoughts after the meeting, you can get in touch with Krista, and we will, we would like to have consensus. We would like to have a consensus from the group. We do need to make a decision on this, and in order for Jessica and Victor to know how to go forward on this issue, which will affect some of our other statutes. So, but we don't have that, and from today's discussion, and so I guess we will see if there's any ways we can take the concerns that have been raised here and maybe come up with option 3. Let's see. So that is all I have. Krista, anything else before we close?
I think we're out of time for anything else at this point.
Okay. All right. Well, thank you all. We appreciate your time.
Bye, everyone.